The mother walked into court determined to block all visitation, no matter what. She thought she could outsmart the courtroom. Every excuse she gave sounded convincing, until the judge started tearing them apart. The father's right to see his child became the center of a heated courtroom battle. One by one, the judge exposed the truth behind every claim made in court. What the judge said at the end left the entire courtroom completely speechless. The judge stayed calm until this happened.
All right, Ms. Sewell, this is your motion to modify the personal protection order. What is it that you want the court to do and why?
It was suggested after our front of the court hearing to modify it so Jeremy would have a way to communicate with our daughter. So that was the only reason why I was modifying it, because referee has legal was suggesting to modify that for communication purposes.
And how do you want it to be modified? What do you want it to say and how do you want to do it?
If I have to be honest, I have my reservations just because of what we've been going through. I just don't want a harassing amount of phone calls and text messages to Liliana, because we are in the process of trying to do reunification counseling, and Liliana's been doing her own counseling for a while now, and we've been kind of working through a lot of things. But I don't want this to regress her, because she does not want to actually speak to her dad right now.
How old is your daughter?
She's 9. She'll be 10 in July.
PPO is as to you, is that correct?
Yes.
So it does not prevent him from talking to his daughter?
Correct.
All right. So the only issue would be, how is he going to get a hold of you to set up parenting time issues for the daughter? Is that correct?
Yes. And I'm fine with him calling. Originally, he was supposed to get her phone to Liliana. He was supposed to scrub it or factory reset it and somehow get the phone to us, but that never happened. So I'm okay with him calling or trying to set up a phone call via text. I just don't want it to go excessive.
All right. Do you have an app on your phone that you would like to use? There are apps such as, I think it's called App Close, that I've heard of parents using in the past, which allows and I don't know the advantage of the app over just normal texting, but I think it has a feature by which you can screenshot and take pictures of the text messages for proof purposes in the future. If you aren't familiar with that, I'm fine with normal texting. That has the advantage of still being capturing what is exactly said between the parties, which can be brought into court later and proven as to what was said and when it was said and who said it, which is the major thing that the court prefers, is to have some record of those kinds of things. Using the telephone, people say things and there's no record of anything at that time. Mr. Azuara, what do you prefer?
Well, like she said, my daughter has her own phone. I'm working on getting it. I was going to get her phone to her when we first go to counseling. I've never harassed her. I mean, even when she had her phone, it was maybe a 5-minute conversation on the weekends just to say hi.
I'm not asking you, Mr. Azuara, I'm not asking you to redo the PPO. I'm simply saying, what type of messaging service would you prefer?
She can email my mom for things and relay messages through that way. Like I said, my daughter's 10. If I pick her up from school, Mom, if there's anything we need to know, she can simply put it in a little note and put it in her backpack. I know all her healthcare providers, so I can always call and get appointments. I usually the ones that set that up. Um, I mean, so I'm fine without going any further things. I have no intention of communicating with her, with the mother.
All right.
I mean, everything's pretty cut and dry now that she's going into fifth grade next year. My mom has worked talking with Christina in the past. They do communicate. My mom has no problem relaying email messages. Um, I mean, that's really all I have to say about that. The only thing I would like to modify is to get my firearms back. Um, the sheriff never took it. They just told me to stash them with a friend or a family member. I have no history of violence or criminal record. It's coming up on camping, hiking season. They're for self-defense only, and I just want my firearms back. Other than that, whether it gets modified or not, um, I can do everything through my mother or Liliana. She'll have her phone back. There's after 7 years, there's nothing positive that's ever come from the mother and I communicating. I don't see it changing anytime soon. So I really don't care if it gets modified or not. I mean, if anything I need to tell her, I can just email my mom and say relay this, and
All right.
that's that.
Ms. Sewell, under those circumstances, do you still want to have them PPO modified?
If it is strictly for Jeremy and Liliana to have a relationship, that's fine. But I personally, we're really in the thick mud right now because she does not want to talk to her dad at all. So again, I don't want him
There's nothing that requires her to talk to him, but there's nothing that prevents him from talking to her. So the PPO is the only thing that I have in front of me. PPO says no contact between the two of you. He's telling me he doesn't want to have contact between you. So that doesn't appear to be a reason to modify the PPO at this point. Is there anything that you want to be able to tell him on occasion that you need to have? Well, the PPO isn't against you, so I suppose you could do whatever you need to do. He's the one that's going to get in trouble if he contacts you. So it appears to me there's no need to modify anything. He doesn't want to have contact with you. I can't make him have contact with you. You're still able to, if he sends you harassing messages, you're able to enforce the PPO. So it appears that you can do whatever you need to do. He's not going to be able to talk to you. He appears to be fine with that. So at this point, I'm just going to say leave the PPO as it is.
Okay.
If he wants to talk to his daughter, he can make those arrangements. If you don't want him to talk to her or she doesn't want to talk to him, that's your prerogative as a mom, and he can take that up with the child support, or excuse me, with the parenting time and custody issues.
Okay.
All right. So case will be the motion to amend the PPO will be denied for those reasons. All right. That's all for today. Thank you very much.
Thank you. Have a good day.
You too.
We are. Your salts are not here, but the Hoosier Brown matter, they're both here.
We're a little early, but I think the parties are present, so call the next case, which is Abigail Hornstra, Jamie Brown, file 23-19492-DP. Do see Mr. Brown is present. Here's Ms. Hornstra is present as well. Looks like this is an objection to the referee's recommended order. Mr. Brown, this is your objection. Why don't you state your reasons and what you're asking the court to do?
I'm asking for everything to go back to how visitations were before, because I do not see any reason for any change.
Did you show up for the referee hearing?
No, there was a apparent. I had everything in a big file, and then I accidentally missed the time. I did still show up, but it was not on time.
So did you get a chance to offer evidence and make your arguments in front of the referee?
No.
Well, an appeal, which is what you've done, has the right to have me look at it with fresh eyes, but that doesn't necessarily mean that you have the right to present new evidence that you could have presented at the last hearing. What you told me is you messed up and missed the hearing, but it doesn't seem to me like there's a valid reason for doing that. So all I would be doing is looking at what was presented to the referee that Ms. Hornstra already presented, and deciding whether or not the referee made an error of law, or whether I think that there's some valid reason for changing what was done. And in general, that's not likely to happen. I suppose it could, but it's not likely to. Why do you believe that there was an error made other than you don't like the outcome?
Because I have missed a lot of time with my daughter Emberlyn because of it, and it is going to end up ruining mine and her relationship. There was no facts or actual evidence
From you, but I believe that she presented facts and evidence to the referee, and that's why he made it says after I'm reading from the referee's recommendation. It says after testimony from the plaintiff, so facts and evidence were presented to the referee. He then reviewed the factors for proper cause and change of circumstances and went through the best interest factors for the Michigan child custody case. He then made a decision that you would have joint legal custody. She would have primary physical custody. You would have supervised parenting time every other Saturday, and then on Sunday as well. Holidays as the parties agree, and additional parenting time as the parties agree, with the option of being unsupervised. So how is that preventing you from having a relationship with your daughter?
Because there's only certain amounts of time that I'm allowed to have with them, and with both of my daughters, with Emberlyn and Athena, and it really ruins the time that they have together and with me.
Your legal argument is that you do not agree with the proper cause or change of circumstances. What do you disagree with about the referee finding that there was a proper cause to change the custody and parenting time?
I believe that there was no proper cause.
I understand that, but what do you disagree with in his determination? What facts? You're telling me your conclusion. You're telling me a conclusion. What are the facts by which you believe that there was no cause to change it or basis to change custody?
That it was just over all hearsay, basically.
If you weren't there, how do you know it was hearsay?
I don't exactly. I just know what she said she was going to say, Your Honor.
All right. Anything else that you want me to know, Mr. Brown?
Not that I'm aware of at this second.
All right. Ms. Hornstra, is there anything that you want me to be aware of?
There's actually quite a few things. Like it says, he has supervised visitation. When he does come to said supervised visitation, he's been taking maybe 3-4 hours and sitting on his phone. I have cameras in my house that can document that.
Hang on a second. Today,
A custody hearing can completely change the outcome of a case, and this hearing proves it. The judge makes it clear that appeals are not second chances. They're about proving legal mistakes were made. Then the allegations involving injuries to a child shift the entire mood of the courtroom. Suddenly, this case becomes far more serious than simple co-parenting drama.
is not about what he's been doing since the court order. Today is only whether or not I should, for some reason, change what the referee did at the time that the referee made that decision. So the only thing I'm going to look at, what I'm likely going to do is review the video of the referee hearing. So the only thing that I'm going to hear from you today is what happened at the referee hearing, and anything different that he hasn't told me already.
Not really. He's had no contact with his daughter for 3 weeks, so I don't think there's any need to change anything.
All right. What was the reason that you gave to the referee to want to change custody at the referee?
Our daughter, who is going to be 3 next month, has came home with 3 black eyes, a bruise on her thigh, a bruise on her shoulder. I had to take her in for an abuse report. And then my daughter also came home saying Jimmy's wife hit her in the eye with a spoon. So I am very, very scared for my child's safety, because a 2-year-old just doesn't make that up.
And was that the reason that you gave to the referee to ask for a change of custody?
Yes, because I believe there's some abuse there.
All right. Anything else that you want me to know, ma'am?
Nope.
Mr. Brown, any final comments?
That I have had DHS and CPS at my house multiple times for all of these allegations that I have had to deal with, and they have never found any proper cause.
There's a difference in proper causes between what DHS or CPS is looking for and what the referee is looking for. Anything else that you want to tell me?
No, Your Honor.
All right. Well, what I'm going to do then is I'm going to get a copy of the referee's hearing. I'll review that. I'm not going to accept any additional evidence. The court rule doesn't require me to look at new evidence if there was a reason that it wasn't presented at the previous court hearing, or there wasn't an opportunity. So I do find that there was a previous opportunity. Mr. Brown simply missed that opportunity through no fault of the plaintiff, of Ms. Hornstra. So I'm simply going to review with fresh eyes. It's called a de novo review, or a new review, but I'll limit it to what was done at that hearing, and then I'll issue a written decision about whether or not it should be overturned or not, and I'll send that out to the parties as quickly as I can. All right, that's all for today.
Thank you.
-DM. The attorneys can place their appearances on the record, please.
Attorney, I'm the only attorney on the case, Your Honor. Defendant and counter plaintiff's attorney Morgan Neal, Courtney Cadat, Legal Services of Northern Michigan.
Thank you, Mr. Cadat. I do see Austin Neal is with us, and Mr. Cadat, you represent Morgan Neal, is that correct?
That is correct, Your Honor.
All right. This is another pretrial conference. Mr. Cadat, from your perspective, what issues remain outstanding?
So, Your Honor, as far as property division goes, we're still waiting on the domestic relations verified financial information form from Mr. Neal. We we have a good communication network going between us to get those documents and information to me. I anticipate those soon. I would request perhaps it would be helpful to give the Mr. Neal a deadline to submit that of 14 days from today for the DRV FIF form. We've already submitted ours to him over a month ago. Aside from that, there aren't contested issues regarding property that we're aware of. At least we can't tell that until we get his information. As far as child custody and parenting time is concerned, there is a friend of the court evidentiary hearing scheduled for Monday, the 13th of April at 1 p.m. However, we've just this week signed an agreement for a temporary order regarding custody and parenting time. I did get word from the friend of the court via voicemail this morning that we are expected to still appear at the 1 p.m. hearing. It can be via Zoom, just to put the agreement on the record.
All right. Mr. Neal, is there any other issues that you're aware of besides those raised by Mr. Kadat?
As far as I know, no.
All right. He's asked for the financial information that's typically required in these cases to be produced within the next 14 days. Do you anticipate any problem with that?
I do not, Your Honor.
All right. Do you have any additional information that you wish to have from the other side, the other party that Mr. Kadat represents?
No, Your Honor.
Mr. Kadat, are there any other discovery issues besides the financial documents that you're aware of at this time?
No, Your Honor.
All right. So I'm simply going to indicate financial information to be provided within the next 14 days. That'll be the discovery side of this thing. Mr. Kadat, do you believe that witness and exhibit lists would be necessary in this case?
No, Your Honor, I don't.
All right. It didn't sound to me as either. I'm going to indicate that custody and parenting time issues are still outstanding. Are there any other? You mentioned that you don't think that there's many property issues. Is there anything that I need to be aware of, that you're aware of, Mr. Kadat?
No, sir.
All right. So I'll simply maintain custody and parenting time issues outstanding. Do we need to make a referral to mediation services of any kind?
As far as I know, no.
I don't think so either, Your Honor. Although that could change if there's a surprise in his financial information form. I don't anticipate surprises, but if we could make self-referral if we needed to.
All right. And is that acceptable to you, Mr. Neal?
Yes, Your Honor.
All right. With the proposed agreement that's going to be put on the record next week, Mr. Kadat, do you anticipate there's any need for any further thing other than a pro-con date in the future?
I do not, Your Honor.
Mr. Neal, is there any other anything else that you can think of that would be necessary for the court to resolve other than the last hearing where we would take the proofs or take the evidence and grant the final judgment of divorce once that's been put together?
No, Your Honor.
All right. Mr. Neal or Mr. Hootie Neal, do you anticipate putting together the judgment of divorce, or is Mr. Kadat going to be doing that?
Honestly, I was going to leave that up to discussion between the two of us.
All right.
It doesn't really matter to me either way.
Mr. Kadat, do you need me to jump into that, or do you think the two of you can resolve that issue?
We'll get it taken care of, Judge.
All right. So what I will propose is simply setting this, the court staff setting this for a pro-con hearing in the future. Mr. Kadat, how long do you anticipate you might need before that would be ready?
Let's see. The case was filed on December 19th, so we could, in theory, have the case entirely resolved by May 19th. If we could do it for the last week of May, let's try.
All right. I will say set for a pro-con hearing near end of May. And I'll put in parentheses after May 19th. Anything else that I need to add to the order, either party?
No, thanks, Your Honor.
No, thank you, Your Honor.
All right, that's all for today then. Thank you both very much. Appreciate your time.
You're welcome. Have a good day.
You're welcome.
too.
Thank you as well.
All right, the last case on the court's docket for this morning is Calvin Green and Alicia Green, file 18-17218-DM. Who do I have present for that case? Looks like we have Alicia Green and Calvin Green is here. This appears to be an objection to the referee's recommended order by Mr. Green. Mr. Green, you want to tell me what it is that you're objecting to and why?
I'm objecting to the specialists for reunification, and then also objecting to the agreed upon time after.
The referee's recommended order as to a specialist, I'm looking for where it says that there must be a specialist. It says that you as the plaintiff are to contact a counselor to have joint meetings / reunification with yourself and the child. The cost of the sessions will be paid for by you, but I don't see any specifics in the order about what type of counselor you're supposed to get. So what is it specifically that you believe that you're objecting to?
Yeah, I read that it said that I needed a counselor or a therapist that's specialized in reunification.
You need to have a counselor that's going to help you with reunification. So they need to have some ability to do that, but I don't know that they need to have any letters or after their name that says reunification counselor. So you just need to have somebody that's a therapist or a counselor or social worker that can assist you with the reunification process with the child. Does that help clarify things?
I mean, when you mention to a therapist or a counselor reunification, they say we don't do that.
I can't help that. So you're going to have to find somebody, but the order itself doesn't specify the level of schooling or the type of counselor that would be willing to do that. You are going to have to find somebody, but there's no specific counseling certificate or specific type of counselor, or it doesn't specify that you have to have a doctorate, a psychologist or a psychiatrist. It could be anybody that has sufficient learning to be able to assist you with reunification of a child. And so it may be difficult for you to find that person, but there's no limitation other than that they have the ability to help you with reunification. I don't know what else I would be able to assist you with in interpreting this order, or what you would specifically be objecting to. Are you objecting to having a counselor at all?
I guess that then. I would just like to sit down at a dinner and with my daughter and talk with her for a couple hours. That's it.
Well, that may be what you want, but that may not be what your daughter needs. And I think that's typically why the counselor is used, not necessarily for your purposes, but to ensure that the child is able to comprehend and process the reunification process. I don't think anybody's saying that you need to go to a counselor just for you. That may be true.
That.
You may want to.
That.
Right.
I didn't
so
say that I need.
I'm not assuming that. what I'm assuming is that the counselor is for the benefit of the child. And that's, in general, that's how the process works. The court has done that forever. There's nothing new about that process. Any time that the child has had an issue or issues that might need additional counseling, we typically will use a counselor in the process at some level of reunification. So what I'm telling you is the referee's recommendation is right down the middle of how we always or normally do things. Is there some reason why you don't think that your child needs any counseling at all about the reunification process?
I don't know, Honor.
Well, it's hard for me to base decisions on things that you don't know. I typically, when somebody comes in and they have an objection, they have a specific reason why they're objecting to it, and they can give me the basis upon which they are objecting. It sounds to me like you just don't want to do it.
No, I'm sorry. I can't find a reunification therapist or counselor here in Gaylord. I can't.
Well, then maybe you need to expand to where you look. Traverse City, Alpena, Mount Pleasant, Sault Ste. Marie.
So
I can't make people magically appear for you, but I do know that they're out there. I've had them used in the past.
So all I was asking was to lift it from a reunification just to a therapist session.
I don't see any problem with you having a therapist. I don't see any violation of the court's order. It says by contacting a counselor. Any counselor would do. All right. Your second request or second issue was you wanted additional parenting time, and as agreed, there has never been an agreement. And the order does say additional parenting time shall be as the parenting time agreed. That's a little bit not written very well, but what I take that to mean is that not that you've agreed to it in the past, but additional parenting time will be as your parties agree going forward in the future.
Correct.
All right. So what are you objecting to there?
That there's never been an agreement, so I'll never get time.
Just because there's never been in the past doesn't prevent you from reaching one in the future. Have you tried?
I don't get makeup time. I don't get any extra time. I don't get anything. Unless you guys order her to do it, and then she still doesn't follow the orders.
All right, Mr. Green, have you proposed specifically to her an additional or a request for additional parenting time? That's a yes or no question, sir. Have you proposed additional time for parenting?
No.
All right, then you need to do that. If she doesn't agree or doesn't attempt to negotiate with you, you have the right to request an additional motion for parenting time. But the referee's recommended order says that you have the right to negotiate now. There's really nothing to object to there. So I'm not going to change the referee's order because you haven't complied with it already. Ms. Green is required to negotiate in good faith. I'm not going to make either one of you do a specific thing, but you both need to negotiate because that's what the referee's recommended order says. And so if you're not able to reach an agreement after attempting in good faith to reach an agreement, you, Mr. Green, have the right to file a motion on specific parenting time. But you have to follow the recommended order first and attempt to negotiate first. And Ms. Green needs to negotiate in good faith as well. The third bullet point that you have on your objection says see attached. And that says, basically going back to the family reunification specialist that we've already talked about. Is there any other, or are there any other objections that you have, Mr. Green, to the referee's recommended order?
I guess I would like to make it up to the child, make the decision when she wants to come to my house.
How old is the child?
16.
So if the child says, I don't want to go to your house, you're going to be okay with that?
That's perfect fine.
What if the child says, I don't want to go to your house ever?
That's perfect fine. But if the child in the future, if the child wants to come to my house, she's more welcome to come to my house. As you state, in the future, it could happen.
You can do whatever you want to do. Right now, I don't see that as something that's a proper objection to the court's or the referee's recommended order. So if you want to not negotiate.
That's what Alicia was, we went to court for. Because she wanted the kid to have the decision.
I'm not here today to renegotiate anything between the two of you. My only purpose in being here today, and your only purpose in being here today, is to address your objections to what the referee did. I don't see what you've just brought to my attention to be anything of what the referee did.
So the referee took away my overnights and all my time and gave it to her, up to our discretion to make up my time. And I'm asking for just to give it to the kid instead of giving it all to her.
What parenting time did you have prior to the referee's recommended order?
This final hearing delivers a major reality check about parenting and responsibility. The judge makes it clear that rebuilding trust with a child takes effort, patience, and structure, not shortcuts. Across every case today, one message stood out. The court's focus is always the child's well-being first. If these courtroom moments shocked you,
The standard guide time, 105 overnights and every other Wednesday.
Then why would there be this need for reunification if that was true?
Because the kid hasn't came to my house in a year.
Well, then you didn't have the standard. You didn't actually have it. It might have been ordered, but you didn't actually have it. There needed to be a reunification process because you haven't had parenting time, as you say, in a year. I'm not going to put a 16-year-old in charge of the bus. This is a parent's decision. Your job is to go out and make it happen. You can't find a counselor, that's on you. They're out there, find one. And you can have some parenting time with your child. I can't, I'm not going to say you don't have to talk to anybody ever. The child just gets to come over whenever. And you're either going to be a good dad or you're not. That's up to you. But you're going to have to find the counselor. You're going to have to reintroduce yourself to the child, make sure that the child's okay with it. If you and Ms. Green want to have a bad relationship, that's up to you. I'm not going to do it with the child. I'm going to deny all your requests at this point. If you need to have additional parenting time, you can file a motion in the future. But it appears to me that the referee did what he's supposed to do.